Yes. Unless you comply with the High Court requirement of the High Court rules, you'll have to take, we can't recuse you. As per the High Court rules, you will file an application. Item number? Item number? 13. Okay. You gave an adjournment slip. Okay. Both sides are represented on the prayer made by Mr. Z. Hussain and counsel for the, sorry, Z. Hussain and counsel for the petitioner. List after 2 weeks. Yeah, give a date is 21 matter after 2 weeks. Yes.
17th of August.
कल का बना ही दिए थे
11 is 21 matter. Okay, 11. Both sides are represented on the prayer made by Mr. T.K. Dale and counsel for the petitioner. List on, give a date after 2 weeks. Four weeks is again 21 matter. You have to wait for some time. You have to wait till the matter is called. Twenty. No, these are tax matter. We can't adjourn it now. These all are batch matters. We can't adjourn one matter now.
Daily list item 1 for motion.
Lordship,
Yes.
Lordship,
Yes.
Lordship,
Yes.
Lordship, I beg to mention item number 22, Lordship, for an adjournment. I'm at Varanasi, Lordship, and I'm petitioner in person.
Item
22, Lordship.
22.
Lordship, I'm petitioner in person and I'm at Varanasi, Lordship.
Okay. But the other side is not there. You'll have to renew the
I'll
prayer.
inform them, Lordship, through mails. I'll inform them.
No, you have not taken a prior consent. Correct. We'll pass orders when the matter is called. We take notice of your statement. You may not be there, but we'll pass orders when the matter is called.
Lordship, there were additional facts to be placed on record, Lordship.
No, we understand, but we can't pass ex parte orders.
Sir, Lordship, I just need a short date, Lordship.
We take note of your statement, but we'll pass orders when the matter is called.
Lordship, obliged, Lordship. Lordship.
Yes. Monday, we have plenty of matters already fixed. Make it Wednesday. They have been, they have gone. Okay. Item 16. 16 and adjournment slip was circulated. Okay. Both sides are represented on the prayer made by land counsel for the petitioner. Matter stands adjourned today. List on, give a date after 2 weeks.
17th of
Hmm? No, it's 19 matter, we can't adjourn it, we'll have to take it up. No, it's okay. You know that why it was not issued. Maybe the court was not satisfied at that point of time. Last time also it was adjourned on your prayer. Yes. Yes. Just put on your speaker.
Yes.
Yes.
One of the petitioner filed written statement, my lord, that is page 20, my lord. In paragraph 4, my lord, paragraph 3, my lord, the real fact is that on second party was born and brought up at village Nis Porua, Moja, Baguribari, and PS Kasumara, district Barpeta, Assam. And my lord, point number 4, after born, my parental family member is shifted from Nis Porua to village Tampupara, Pathar, due to erosion problem of Brahmaputra river. And before 1997, our parental family members is shifted from Tampupara, Pathar to Duramari, Digalsura. And presently, our parental family members is residing at village Bitarduar under Kamrup district. Next, my lord, that before 1997, I, along with my family member, is shifted from Duramari, Digalsura to Chandanpur, and at present I am residing. Presently, he is residing Chandanpur, my lord. And 3 times my lord shifted in this case, my lord. That the father's name of second party is Kurban Ali, alias Kurban Ali. Mother's name is my lord Moiron Nessa, and they are still alive, my lord. That the parent of the second party is a permanent resident of Assam, having adequate document. As such, the second party is also permanent resident of Assam and a bona fide citizen of India by birth with documentary proof in support of Indian citizen. That the grandfathers of the second party, Jan Mahmud, grandmothers Aimuna Khatun, and fathers Kurban Ali's name were recorded in the voter list of 1966 by serial number so of village Nis Porua, Moja, Baguribari, PS Tarabari district Kamrup. That the fathers of the second party, Kurban's name were recorded in the voter list of 1970 of serial number so and ballot of 56 number Soigao LSC at village Champupara Pathar in the district of Kamrup. Next, my lord, that the fathers of the second party, Kurban Ali, mother Moiron Nessa, and own name were recorded in the voter list 1997. My lord, his name first time recorded in the voter list of in the year of 1997 with his parents' name. Serial number so and 49 number Soigao LSC, my lord, in village Duramari Ka, Digalsura, and my lord, district of Kamrup. Next, that my name has been shown in the voter list of as D voter list of 1997, my lord, and the same year, my lord, the name also put D, my lord. And next, my lord, paragraph 13. Second party's actual name is Maqbul Hussain, father actual name is Kurban Ali, and grandfather actual name is Jan Mahmud. but my name has been wrongly written in the voter list of 1997 by serial number so of Sangha LSC, village Chandanpur, district Barpeta, Assam, and notice of FT case Makbul Hussain instead of Makbul Hussain. And my father name has been wrongly written in the voter list of 1970 as Kurpan instead of Kurpan Ali. And also, my grandmother name has been wrongly written in the voter list of 1970 by its serial number so in the Soigao LSC, village Champupara, Pathar, against my father's name as Janu instead of Jan Mahmud. Jan Mahmud, full name is not written here, Janu only. And the voter list of 1997, serial number so house number so and 49 numbers, Soigao LSC, will Duramari and district Assam, against my father's name as Janumia instead of Jan Mahmud. That Makbul Hussain and Makbul Hussain is the same and one person. That is myself and Kurban Ali, and Kurban is the same and one person. That is my father. And also Jan Mahmud, Jamu, and Janumia is the same and one person. That is my grandfather. That the parent of the second party is a permanent resident of Assam. As such, the second party is a bona fide citizen of India by birth. Next, that father was examined, that's DW2 here, and he also submitted the evidence in SIP as affidavit, that is page 25. Here also, same way, stated of written statement. And next, page 29 is the voter list of 1966. Page 29 is the voter list of 1966. DW2 father. Yes, yes. Father deposed. Page 43 Page 43 evidence in SIP and affidavit. I have no close part because petitioner could not supply me mail. The only SIP I have annexed mail. I am reading mail. (1997) total list mail. Page 35 mail. English translated and original one 36. Page 36 mail. But that is only the linkage, and father also is still now alive, and father deposed before the court that the present is the son of the DW2, and shifting is there. What happened, in illiterate person, different time, they shifted one place to other place, and some name discrepancy and age also discrepancy here because they could not calculate accurately, and these are happening. In fact,
Out of so many documents, I have asked you only to tell us about DW2. The reason is, come to page 43. At 43, paragraph 3. Before 97, my son again shifted from Duramari to Chandanpur. Correct?
yes, at present he is in Chandanpur.
Come to page 34. No, sorry, not 34. This 1997 is page 36. In 77, 1997 voter list, both are together.
1997 with Karen but when put D thereafter
We don't know. It's your statement. That's why I wanted only one statement from you.
in deposition
Page 43, paragraph 3. Before 97, son shifted, but son and father are together in 1997 voter list.
So my son is again shifted.
No, that's okay. That is only one part. It's only one part.
The 66 and thereafter 70 is voter list find out only his father's name. But name is Ramu. Thereafter, the DW3, Gauhati certificate, that is test 41. he dealt with three minutes as Gaurav was examined. But I have to know that close part of the Gaurav. Gaurav certified that the Maqbul Hussain, the son of Furqan of Chandanpur, that time they were residing in Chandanpur. Still now they are in Chandanpur. And DW3 was examined as Gaurav, but his deposition was not accepted by the learned member. Discuss not believe yes not believe. The learned tribunal that time the close part not supply therefore I could not annex my submission that that since father is Indian citizen, father is Kurban Ali Millet, and he is also Millet, son of Kurban Ali. So the opinion Millet will be decided.
My humble submission is that, Lordship, there is no infirmity in the opinion first by the learned tribunal. Lordship,
There is one issue you will have to address.
Lordship.
This is coming almost regularly. Insofar as the rejection of voters list are concerned,
Yes, sir.
the voter list was certified copy. And the tribunal is relying on one of our decisions regarding the secondary evidence, that it's a certified copy, and therefore primary evidence has to be satisfactorily explained. But you have to address us with regard to the element of public document. So whether, so far as the certified copy of voters list is concerned, is it a requirement of law that without treating it as a public document, the secondary evidence which is envisaged as section 65 must be complied with, and 74 and 76 should be omitted.
Okay. I will address on that point, but first of all, Lordship, if we see the record, Lordship, see the petition, Lordship, and there is no link at all between his father and his projected grandfather, Lordship. Lordship, in his evidence, father's evidence, Lordship, father says that, Lordship, my father expired 10 years ago or 8 years ago, something like that, Lordship. But after 1970, Lordship, there is no existence of the grandfather of the proceeding, Lordship. 1966, grandfather's name was reflected as Jan Mahmud.
1966.
Yes, page 30. Page 30, vernacular, Lordship. Here, projected grandfather is Jan Mahmud.
Just a moment.
And projected father is
Just a moment.
Kurfan Ali, last entry.
1966. Jan Mahmud is 48.
Yes, aged about 48, and last entry is Kurfan Ali. He is the projected father of the proceeding, Lordship. And Lordship, WS is totally fake, Lordship, regarding other entries. Who are those persons?
Just a moment. Jan Mahmud, you had referred, then you had referred to another name. What is that name?
Kurfan Ali. Kurfan Ali is the projected father.
Kurfan Ali. Okay. Yes.
So after 1966, Lordship, this Jan Mahmud is totally disappearing, Lordship.
You already expired in our first question.
No. In evidence, I have seen somewhere. Lordship, para 13 of the impugn opinion, page 51. Then it is also evident during cross-examination, Kurpan Ali, DW2, deposed on oath on 1/8/2018 that his father expired 8 years ago. If DW2's father expired 8 years ago, that means during 2010, Kurpan Ali's father was alive. But the voter list of 1970, 1977, 1997, and 2008, the father of Kurpan Ali's name does not appear along with DW2 in any of the above said voter list. As a result, these voter lists are doubtful voters list, and it is not safe to rely upon the single entry which is not true. So, Lordship, after that, Lordship, after 1966 voter list, it is of village Nispurwa, then 1970, this is of different village, Sampu Parat Pathar,
Take us to the document, otherwise we will not remember.
Lordship.
Take us to the document, otherwise we will not remember.
Lordship is not audible, Lord.
No, no, please refer to the document, otherwise we will not be following you. Take us to the
Lord.
document.
After 1966 voter list, Lordship, page 32, this is voter list of 1970, where
Yes.
projected father's names appears, and he is connected with one Jammu, and not Jan Mahmud, Lordship. And this is of different village, Lordship.
Yes.
And the Lordship, my humble submission is that present proceeding Mokbul Hussain, son of Kurpan, is a resident of village Sandanpur, and reference was made against Mokbul Hussain, son of Kurpan, who is resident of Sandanpur.
No, no, there is a issue there.
Yes.
In the deposition of DW3, he says in 1985 these two villages were merged. Get it here. It will be, no? 1985 villages merged and Sandanpur was merged. This is at page 57 of the EPCR. It, '57 in the examination in chief.
Page 57.
55-7.
Merciful Chandanpur. And he is present to examine Chandanpur, India, 1955. This village, Nishpur and Chandanpur, was nice. Yes, probably. I know the able to living online. Lordship, yes, Lordship, the first that Nispurwa and Chandanpur village was merged and presently known as Chandanpur village. But in cross Lordship, he says that I have heard that Kurpan Ali father is residing at village Pitordwar. Mokbul Hussain went to my house and asked me for a certificate. I know Mokbul Hussain is suspected to be an illegal migrant by the state referral authority. I have taken the risk by giving the certificate to a suspected illegal migrant, Mokbul Hussain. I know the duties and function of the Gabura. I have issued the certificate as a residential certificate. I do not maintain public record. I have not. Yes, Lord. Yes, Lord. I have not read an error about the executive instruction part 8, chapter 8 of the Assam Land and Revenue Regulation 1886. This certificate is a residential certificate. I have issued the certificate on the basis of voter list. I have not produced the voter list before this tribunal to show that Mokbul Hussain, the father is a registered voter. I do not know the name of mother of Kurpan Ali. I have not produced any documentary evidence before this tribunal to show that the village Nispurwa and Chandanpur are merged as one village. So Lordship, it can be taken as only oral evidence, Lordship. And no? But Lordship, proceeding.
He did not say that.
Proceeding, Lordship connected to link, trying to connect his link with Kurpan Ali, whose name reflected in the 1966 voter list. But Gaubra says that this Kurpan Ali is originate from Pitordwar, not Nispurwa, Lordship. Here, 1966 voter list is of village Nispurwa.
Oh, please read that part again. We missed it.
Lordship, Gaubra, in his evidence, Lordship, says that I have heard that Kurpan Ali father is residing at village Pitordwar. Oh, I have heard that Kurpan Ali father is residing at village Pitordwar. But Lordship, here, Lordship,
Is deciding at?
here, Lordship, 1966 voter list is of village Nispurwa.
No, that, what is that village is residing at?
Pitordwar. Bhitor, Pitordwar, Duar.
1966 is Nispurwa.
Yes, Lordship. And and there is no reflection and Gabra's evidence does not reflect about a Sampapura village lordship. That because 1970 voter list of village, page 32, Sampupara Pathar, 1972. Okay. 1970 voter list, page 32. Here only Kurpan's name reflected and connected grandfather's name was reflected as Jammu and lordship. In 1977, page 33, 34. Nineteen 1977 village, page 34. 1977 voter list, page 34. It is again a different village lordship. Ujan Duramari.
Duramari, Jan.
And Gauhati also did not reflect about this village lordship.
Yes.
After 1977 lordship, up to 1997, there was a gap of 20 years lordship. Between this period lordship, there is no voter list, no any document lordship. So there is a lack of continuity. That person concerned is continuously residing in the territory of Assam since 1966 lordship. And here again lordship 1997 village is again another name Lordship, অঞ্চলৰ নাম দুৰামাৰী ক দীঘলচোৰা. Again, different village, Lordship.
Yes.
So, Lordship, first of all, Lordship, proceeding has to establish his father's link, Kurpanalis, with his grandfather, whose name was reflected in the voter list of 1966, Lordship, as Jan Mahmud, Lordship. So, Lordship, in this case, there is, I could not find such a link between Kurban Ali and Jan Mahmud, Lordship. If you compare the 1997 voter list with 1966 voter list, Lordship,
It will be village planning. Eight. Eight.
so Lordship, although fathers deposed before the tribunal, okay. So, Lordship, although father deposed before the tribunal, but first of all, father has to establish his citizenship or link with his father, Lordship, whose name reflected in the voter list of 1966, and Lordship, here in this case, father is totally failed to establish his link with the proceedings grandfather, Lordship. And Lordship, regarding oral statement, Lordship, here is so many judgment has been passed, Lordship. Oral statement with Lordship. In Noor Begum's case, Lordship, 2023 GLT 347. Noor Begum, Lordship, regarding oral statement, Lordship, 2023 GLT 347. Para 6, Lordship, state, Lordship. The statement of DW2 Zahrun Begum, who claimed to be the mother of the petitioner, cannot be relied upon in the absence of any document showing her relationship either to the projected grandfather, father, or to the petitioner herself. Oral testimony of DW2 alone, since any documentary support cannot be treated as sufficient to prove linkage or help the cause of the petitioner. Surprisingly, the petitioner failed to produce a single voter list in her name even until the age of 50 years. We would reiterate that proceedings under the Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship. So, again, Lordship, on same point, Lordship, another judgment was passed by this Honorable Court, WPC 4020 of 2017. Asia Khatun, here fathers came before the tribunal and deposed before the tribunal, Lordship. Asia Khatun, ASIA KHA TWN. ASIA-KHA-TWN. Date of disposal 21/11/2019. WPC number is 4020/2017. Here also Paras is lordship. That judgment also passed on same footing, lordship.
Okay.
The statement of DW2 Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in absence of any documents showing his relationship to the petitioner. In this, we would observe that in a proceeding under Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidence in the value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship. The evidence of DW2 thus falls short of being considered as cogent, reliable, and admissible evidence, so much so to establish linkage of the petitioner to him. Here, in this case, lordship, father of the petitioner, there is no link between father and of the petitioner and his grandfather, except oral evidence, lordship.
This certified copy of voters list.
Yes, lordship. Lordship, yes, এখনো আছে এই কিতাপখনত বেলেগটা হেৰি কৰি লওঁ তাৰপিছত different method. Page lordship. Yes, doctor, I have copy. 22.
Para 22. This perhaps is wrongly quoted by the tribunal. Read para 22 on a careful and conjoint reading.
Yes, yes. On a careful and conjoint reading of the aforesaid provisions of the Evidence Act together.
Just for the purpose of the complete picture, para 22, para 19 onwards, there's a discussion on what is a certified copy. Para
Yes,
19,
yes,
20, 21 deals with this and the public document. Now come to para 22 on a careful and conjoint reading.
A careful and conjoint reading of the Prohibitions of Evidence Act together with the definition of certified copy, we are of the unhesitant view that a translated copy such as Exhibit A and D cannot be constituted as a certified copies and therefore cannot be treated as secondary evidence. This position is further strengthened if we look at Exhibit A and D because there is no certification by the competent authority by certifying that the extracts are true copies from the original. We may also observe that those certified copies are admissible as secondary evidence. It would be so only if those are issued by the competent authority. Admission of photostat copies, even if attested by notary public, is improper and inadmissible in evidence under section 63 of the Evidence Act. That apart, certified copies documents not coming within the ambit of clauses A or E of section 65 would not be admissible in evidence. That apart,
So therefore, if it comes within 60 A to E,
yeah,
then it is admissible. Correct?
yes.
If it is within A to E, then it is admissible. Then come, please read, continue. No, leave that. You continue with this, then we'll come back to.
Yes, yes. That apart, as a general principle, secondary evidence is not admissible until non-production of primary evidence is satisfactorily accounted for. In addition, we may also refer to section 66 of the Evidence Act, as per which secondary evidence of the contents of documents shall not be given unless
Section 74.
party proceeding to give such secondary evidence has previously given to the party in whose possession or power the document is such notice to produce it as is prescribed by law. In other words, a party desirous of reducing secondary evidence must not only satisfactorily explain non-production of primary evidence, but also must give previous notice to the party who is in possession of the primary evidence. And if despite such notice, the primary evidence is not produced before the tribunal by custodian of the primary evidence, in such a situation, tribunal may invoke its power under Order 4 of the Foreigners Tribunal Order 1964 to issue summons to custodian of the primary evidence and not as a matter of course.
Yes. So this order, in fact, excludes 65E, A to E. 65E is when original is a public document within the meaning of section 74. Seven, 65 would be 66, I think, there in the new book.
When
Okay, 65E.
when the original is a public document within the meaning of section 74.
So this is excluded.
Yes.
So therefore, you see, this judgment of this court is wrongly read to mean as if whenever a certified copy is produced, the original must be called for. This judgment says that if the court doubts,
Yes.
then it may use what you call order 4 and call for the records.
Yes.
But this does not say that certified copies must be proved by calling the original.
Yes, Lord.
This is a wrong interpretation by the tribunal. You will find that observation of rejecting this certified copy this paragraph 17, page 52. After that, generally a specialibus non-derogant. Then paragraph 18. The proceeding in this case have failed to prove the authenticity of voters list of so and so.
Okay.
Page 52.
On which page, Lord?
Of the judgment, page 52.
Yes, yes, yes. Yes.
Hmm? If you could take it on the-
That about certificate of document not. Yes, Lord.
This is a wrong interpretation
Yes, Lord.
of the judgment.
Yes, Lord.
Para 19 is correct, but para 17 and 18 is a wrong interpretation.
Lord. पेपर का था
Any case citations?
Yes.
Which you are relying on which case?
अपने की बात उसमें डिवोट करते हैं
Okay, at present, madam, I have no.
Okay. At this time, the Dean Learning Council for the petitioner and so for the respondents. Pursuant to order passed earlier, the records of the tribunal is received. Next, as the matter it is As this repetition of the year 2019, the matter has been heard at the motion stage. Next para, order reserved.
Item 2 for motion.
Yes.
If the lordship, nothing in this lordship, my senior presence is required, he is not well. He is under treatment, lordship.
Pardon me?
So my senior is not well. His presence is required in this case, lordship, is transfer matter of tribunal. Yesterday he told me for taking time. Transfer matter, not transfer matter. Only settle issue, tribunal. No.
Both sides are represented on the prayer made by Mr. J. M. Suleiman, learned counsel for the petitioner. Matter stands adjourned today. Uh, But we'll have to give a short date because the only issue involved is transfer. Here, the opinion is not under challenge. We are seeking transfer of the proceedings from one place to
Yes,
another.
yes, sir. Officer.
And for last 4 years, the matter is pending.
Yes.
We'll take it up on Tuesday then, this matter. Tuesday, okay? Next para. In this case, the petitioner is seeking a transfer of the proceedings from one learned tribunal to another. And in the process, the proceeding has been stayed for by order dated 7/4/2022, which is not found to be in the interest of justice. Accordingly, it is made clear that on the next date of listing, the matter would not be adjourned and would be heard on the basis of materials available on record. That's the list on 5, sorry, 4/8/2026.
Otherwise, lordship, there is a full bench decision, lordship, in respect of reference, lordship.
No, that's okay. Be prepared with that. That's why.
Item 3 for motion.
May please, your lordship. Lordship, in this case, lordship petitioner declare void our post of 70 lordship, impugned opinion is case 75 minutes. In the last provision, my lord, notice was not issued, my lord. Notice will be issued after period of the reference, my lord.
Yes. Which page is the opinion?
Opinion is case, my lord, page 75 minutes. date of opinion is 23/11/2021, and we have filed a writ petition before this honorable court on 23/2/2024. After 2 years now. Filed the writ petition. This is too hard. This is too hard.
Where is your written statement?
WS minority says. Okay. It's 66. There's 66 to 69, my lord.
69.
66 to 69, my lord.
66 to 16.
66.
I just forget the exhibit number. In this case, the petitioner is an NFL employee since 1955.
Yes.
He produced his pension payment order.
Yes.
That was rejected on the ground that you did not call the original, did not call the employer. Is this the ground? Then in a lighter note, after I superannuate, I'll have to call not less, no one less than the President of India to prove my certificate. But my warrant is signed by the President of India. Or the governor who gives me oath. Is this fair?
No.
It's not fair. Then we'll have to pass an order where we'll have to lay down that each government officer on receipt of summons from the tribunal will have to go to the tribunals and give evidence. The government office will have no other work but to go to tribunals and offices to give evidence. How can pension payment order be? You see this finding, page 77, para 10. And you see the reasons given. Exhibit 1 is not proved by examining the issuing authority. Now, you see, there's something more in this. In the same paragraph 10, this is something which is ridiculous. The proceeding has not explained why the name of Nepal Chandra Nath, who casted his vote in number 58 East Gauhati LAC in the year 71 shifted to 51 Jalukbari LAC. So even in the same city, if one shifts the residence from East Gauhati to Jalukbari, you'll have to give an explanation. Where does this law come from? Now next, turn over to next exhibit 4 and voters list of 1979. Exhibit 3, house number got changed from 167 to 280. It was not explained. Now house number is, change of house number is not explained. Can this be a valid ground? Can you justify that?
No.
Just come to, we are just taking at random the evidence. Come to this finding of page 78. In the third quarter, you will find exhibit 10 is the voter list of 2009 of same LSE, exhibit 11 of same LSE, exhibit 12 same LSE, exhibit 13 voter list of 19. They are not proved by examining the issuing authority. These are certified copies. Rejection of each and every document is perverse. And you know what the tribunal does? Since the 1955 pension document is rejected, the admit card is rejected on the ground that he is the son of a foreigner. That you will find page 78 in the middle. 69 does not stand any person was born in Bangladesh, come to Assam, get admitted in any school. How does this finding come? Monday delivery of orders Okay, we'll fix it on Monday for delivery of orders. We'll have to write this in an appropriate way.
Yes, sir.
Mr. Vishwas will hear you or Mr. Hassan?
I have gone through this matter, but probably I have came to cross this beautiful case. He has exhibited all the documents. She was born, she passed matric, higher secondary. She's working in the ICDS, an Anganwadi worker. If she is a foreigner, how she can work? Then she is a booth committee member at Balipara.
So therefore, we have heard whom? We have heard you or Mr. Hassan?
And Malay Bhutali with her mother.
No, that's different. We are asking, we have heard Mr. Biswas or Mr. Hassan?
No.
Okay.
He has taken trouble, man.
Okay. Heard Mr. Hassan and counsel for the petitioner and also for the respondents. Submissions concluded, order reserved. List on C8/2026 for delivery orders. We'll take a short break and come back.
Item 4.
This I has been filed in pursuant to order dated 3/9/25, my lord. In pursuant to order dated 3/9/25, this I has been filed. What happened in the cost statement, my lord, there was some typographical error, my lord, that was directed to be corrected by filing I. My lord. And at para 2, your lordship will find para 2 of my I, my lord. Due to typographical error inadvertently, the respondent number 5 was typed as District Commissioner, Sonitpur, Assam, instead of Gwalpara. 5 and 6, just the district.
And also for the respondents. Next one. Owing to typographical error in arraying respondent numbers 5 and 6. Comma the respondent 5 and 6 in the connected petition, comma the present interrogatory application has been filed to allow amendment of the cost title with respect of the said respondent numbers 5 and 6 in terms of order dated 3/9/2025 passed by this court. Next order. The amendment is amendment of the cost title in respect of respondent numbers 5 and 6 is allowed to the extent as indicated below. In that, below we make three columns, number 1 and number 2. Second column would be respondent number 5, number 6. Third column would be the old description of district commissioner and the respondent number 5 and respondent number 6. The next column will be the correct one. So it will be in one. It will be in one column. Next for the petitioner. Next for the petitioner, the applicant shall file the corrected cost title of the petition and hand it over to the AOJ FT section
Cost
for
title is
the.
already been filed, my lord. Amended cost title has already been filed.
Where you have filed it?
My lord,
Where have you filed?
it's along with the IO, my lord. Is it not there in the record, my lord?
I don't know. You'll have to file it in the writ petition. Filing it here would not do anything.
Only the amended cost portion or the whole petition. Amended cost title.
Amended cost title to be incorporated in the writ petition and for consequential correction in the CIS data. Next para. The same shall be done within 2 working days. The general counsel of the applicant shall file the same within 2 working days. Next para, list. This interrogatory applications can be disposed of.
Yes, sure.
Item 5.
I plead the law. My lord, the contested case, my lord. My lord, the impinging opinion, impinging judgment, my lord, at page 86, my lord. My lord, the judgment dated 11/6/2014, my lord. The huge delay is here. Yes, my lord, the petitioner was taken into custody on 25/5/2025, my lord. And thereafter, the son of the petitioner, my lord, approached this court, my lord, the criminal writ petition, my lord, habeas corpus. And thereafter, my lord, habeas corpus was closed. And then the, my lord, petitioner come up before this court, my lord. Initially, my lord, the case was pending before the Corners Tribunal, Gauhati. And there, my lord, the petitioner appeared and filed her written statement, my lord, written evidence, and she examined as DW1, her father as DW2. Thereafter, my lord, the case was transferred to Jorhat. The Jorhat tribunal, my lord, issued notice to the petitioner, but the petitioner could not appear. That is why she has no knowledge about the, my lord, the judgment dated 11/6/2014. And my lord, suddenly on 25/5/2025, she was arrested from her own house. Thereafter, she came to me. My lord, the record may call for, my lord, she is in custody, my lord. Otherwise, my lord, she exhibited voter list of 1960, 1961, 85. Her father's name is here, and father was examined as DW2. And my lord, one school certificate was also exhibited.
No explanation in your written, in your written petition about the, after non-appearance, for the reason of non-appearance.
Paragraph 4, my lord.
Para?
Paragraph 4 in my report.
4. So does not say any reason why you did not appear after service of notice. In Gauhati, you were again served with the notice. You don't say why you did not appear.
As per my lord judgment, notice was issued.
Notice was served.
Yes. Correct.
So what is your explanation to that? Why you did not appear? You have got given no explanation.
Start of May. August.
Being taken up on that day. 3rd.
3rd of August. 3rd of August.
3rd of August. All such matters are being listed on that day. That is pursuant to that the recent Supreme Court judgment, that Savitri Day, both of the represented. Similar matters where opinion were passed right, non-appearance of the petitioner, non-appearance of the petitioner. The opinion was passed in a non-hearing petition. Slated SLATED, slated to be listed on 3/8/2026. Next, list this matter on 3/8/2026.
Obliging.
For motion, item 6.
Let raise this one.
Yes,
Your Lordship, the opinion is of 2023, so I'm late this time, Your Lordship. Opinion is at page 29, Your Lordship. Sir, Your Lordship, I have produced documents wherein my name along with my father and mother. were,
it's okay. You'll have to wait for bail.
Yes, Your Lordship. At this time, Your Lordship, notice may be issued. And one more prayer, Your Lordship. My father and brother have already been declared not foreigner by
Where is that?
Your Lordship. Page number page number 90. Your Lordship, that is the opinion wherein my father was declared as not foreigner. And in
90.
Yes, Your Lordship. Annexure 17, page 90. So that two records may be followed, Your Lordship, in connection with this. Yes.
Page 90. Who is this person?
Noor Islam is my father, Your Lordship.
Is your father?
Yes, sir. And Akbar Ali is my brother, Your Lordship. Page 90. Tribunal is different. This is of Fojai, FT Fojai.
This opinion was not produced before the tribunal.
No, Your Lordship. I have produced the opinion of my father only, Your Lordship, not my brother. My brother was declared not foreigner subsequent to my declaration, Your Lordship. I am declared as foreigner on 11/5/23, Your Lordship. But my brother was declared not foreigner on 22/9/2023.
No, no, you are spoiling everything. In paragraph 10 of the impure opinion, that's not the reason. You produced your father's
Yes,
certified copy, but you gave a statement that except for your brother, no case was instituted against the foreigners, tribunal against anyone.
yes, Your Lordship.
Then this opinion at page 90 would not have been of your father. It's a specific statement. Okay.
In my written statement as well as in my evidence, I have not mentioned all that.
And you gave a wrong statement that except for your brother, there was nobody else who had proceeded with. That makes
Yes,
it
sir.
difficult.
At the time of examination, I asked it through.
Okay. Heard Mr. Chakma and counsel for the petitioner and so and so for the respondents. Next para. Right. Finally, this is petition under Article 226 of the Constitution of India from the petitioner, namely so and so. They say the opinion dated 11/5/2023, page 29, passed by so and so in FT case number so and so, police inquiry number so and so, by which he was declared to be a foreigner post 25 to 97 stream. Next part. The learned counsel for the petitioner has submitted that by opinion dated 21/9/2016, page 90, passed by so and so and so and so, comma, the projected father of the petitioner was declared to be not a foreigner and that subsequent to the opinion passed in the petitioner's case, comma, by an opinion dated 22/9/2023, page 92, comma, the projected brother of the petitioner, as the projected brother of the petitioner has been declared to be not a foreigner. Next para. You notice extra copies will include call for the records of three cases. One is page 29, the other is page 90, and the third one is page 92. From the respective tribunals, the tribunals are different. Next para. The prayer for bail shall be considered on receipt of the tribunal's records. Next para. In the meanwhile, if the petitioner, namely so and so, is apprehended, comma, he shall not be deported out of the country without order of the court. Next para. The petitioner shall cause production of a certified copy of the order before the Superintendent of Police, Border, Sivsagar, to bring the order to the notice of the said authority. List on so and so. Give a date after 4 weeks.
Safely, okay.
Matthew,
For motion, item 7.
May please, your lordship. It is a contested case, your lordship. The impugn order was passed on 17/6/2022. Impugn order is at page 76, your lordship, and it's number 24. In this case, petitioner adduced two witnesses, one by herself and another by her paternal uncle.
we issue notice, but we have to wait for bail.
In the meantime, interim order
Third, he becomes under counsel for the petitioner and so for the respondents. Opinion at page 76, dated 17/6/2022, passed by so-and-so in FT case number so-and-so, police reference case number only, by which the petitioner declared to be a foreigner, post 25/3/1971 stream. Notice extra copies given to this, all for the records. The prayer for bail shall be considered on receipt of the tribunal's records. In the meanwhile, if the petitioner, namely so-and-so, is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police Border, Nagaon, giving the order to the notice of the said authority. List on so-and-so. Give a date. 4 weeks.
Oblige, your lordship.
Upgraded item 24 for orders. Upgraded item 29.
Lordship, I have taken the instruction, Lordship, from the concern on within another day, people time could not, person concerned is not appearing before the concerned police, Lordship. Condition for bail was not followed, Lordship.
Okay. He did not appear.
No, Lordship. He did not appear, Lordship, within the period.
That on 18 March 2026, he appeared, madam. We have received the certified copy on 16 March, madam. With solvent surety, madam. As per order passed by the honorable court, madam. We engage an local advocate, madam, of Gauhati district, madam. We are the resident of Dhubri district, madam. We stayed 4 days, madam. So advocate told me that appearance has been completed, madam. Thereafter, madam, we approached the landed court below as per the order of this honorable high court, madam, with WS and witnesses, madam.
We didn't take
But,
this, my lord.
but if you don't appear and take bail in terms of the order, how can we protect you?
After expiry of 10 days, he is appearing, Lordship, he was appearing. After expiry of 10 days, Lordship, he was appearing, that's why bail was not accepted, Lordship.
Madam, the office of the SC border is denying, madam. I think we approached on 18 March 2026 with an engaged advocate with solvent surety, madam.
In fact, you see, you have the IA. Yes, sir. Come to page 9. It starts from 8, come to page 9. This is an order of 13.3. Yes, sir. Correct. Here we granted bail, awaiting the records. Yes, sir. Correct. Now, after this, the matter was listed, come to page 12 on 13.5. Yes, sir. 13.5, the matter was disposed of. Yes. So the interim order gets merged with the final order. There is no requirement of bail now. Yes, sir. It's true, sir. You should get, the interim order would get merged with the final order. So
Yes,
the,
sir. Yes. Actually, according,
oh, acha.
interim order of bail will continue till the completion of the proceeding before the learned tribunal.
No, there's an order, we missed it. My esteemed sister has found it, that last line is that interim bail shall continue.
Yes, sir. Till the completion of the proceeding.
Okay, we'll extend the time then. Speak with me. Okay, we extend the bail then.
Yes.
heard Mr. S. Islam, learned counsel for the applicant, and so and so for the respondents. Next one. By filing this interlocutory application or the petitioner, namely so and so, who is the petitioner in WBC 7279 of 2025, has prayed for extension of time to take bail in terms of order dated 13/5/2026, passed in WBC 7279 of 2025. Next comment. This could, by order dated 13/3/2026, allows 10 days time to the petitioner to take bail or rupees 5,000 with one sovereign security of like amount to the satisfaction of the Superintendent of Police, the bracket border, bracket Saradeo. Mr. However, the applicant submits, the applicant presents that he has appeared before the Superintendent of Police on 18/3/2026. But no receipt of any appearance was given. Next one. This court, by order dated 27/7/2026, had asked had directed the learned standing counsel for the IT and border matters to obtain instructions as to the correctness of statement made in paragraph 4 of the application. Full stop. The learned standing counsel for the IT and border matters has submitted that the applicant did not appear within the 10 days time allowed, but started appearing after
Lordship, after expiry of 10 days, Lordship.
after expiry of 10 days, for which bail could not be accepted. Bail could not be accepted. Next paragraph. Either as it may. In on consideration of the claim made by the applicant, the claim made in this application stands, interrogative application stands allowed by extending the time for taking bail by further 10 days from the date of the order. Full stop. Accordingly, it's provided that in the event the applicant appears before the Superintendent of Police border, Saradio, or the said authority would accept the bail in terms of order dated 13/3/2026, passed in WBC 7279 of 2025. First of, it's specified that in terms of the directions contained in the order dated 13/5/2026, passed in WBC 7279 of 2025, the said bail would continue till the completion of the proceedings before the learned tribunal. The learned foreign tribunal, Gauhati. Next one is applications. Applications and disposal on terms as indicated above. Yes.
Upgraded item 30.
Oh, yes.
Lordship, this is the review on para 67, 68 of the Home Department. 3 departments, Lordship has already issued notice. In this, there's a delay of 67 days, Lordship.
Okay.
Others are also coming up on the 31st August, as in, or 31st of August, Lordship, next month.
Okay.
No. Review is 31st.
Okay. But same thing here, why don't you serve notices to the lawyers, concerned advocates?
It has been served, Lordship. That's what,
No,
not been served.
no,
We
no.
will be doing it, Lordship. Like last time, Lordship has said after delay condoned, give us time 2 days to serve it, Lordship. 2 more are to come also. That is also in the registry only.
Okay. But once you don't serve, you have to issue notice to the party, which could have been avoided.
Otherwise, Lordship may keep it, we'll serve it to the party. That we serve it. Liberty to counsel, Lordship.
No, serve it by Thursday, as we directed earlier.
Yes, Lordship, we'll do that.
You have a copy of that order, dear order?
I have it, Lordship. I'm sorry, it's on my phone, Lordship. I can give it on my iPhone.
Just tell the number.
give it to the court master, sir.
Yes, give it to the court master.
That will be the easiest because that is, and Lordship may keep it on 31st of August because the others are coming up also.
Okay, you are passing the same order, just forward it to my court
I
master.
We'll give it to Lordship. At lunchtime, we'll do it.
This is notice issued in terms of order, we should pass for you. Same thing.
Same, I'll give it to him.
Okay.
I'll give it.
Contradiction of view. Just record the previous officer and police senior counsel assisted by
A. Roy.
A. Roy and
Mr. Dina.
Dina, senior government advocate for the applicants.
Actually, technically, Mr. Dina, then Mr. Aero.
I'm the junior one.
Okay.
He's senior to us.
Dina, cover the proposal.
Great.
What is it? It could be.
Upgraded item 31.
You are saving some ink. You are saving some ink in the process of filing this application.
I have explained everything, Manager.
In the first cost title, you are not even given the days of delay.
So delay will, it is there at para 2 minutes.
So that's why you see from the cost title, why should we read the entire application only for the purpose of delay? Why should we go to paragraph 2? At least the delay is required, there's a requirement of our rules to give it there in the cost title.
The earlier order is an ex parte order. This IA may be allowed in this, all the matters are coming on 3rd. So it may
We
be,
are not allowing this. 340 days.
we were at Honorable Supreme Court, in which the liberty was given to appear, file a review. That was on 27 and 1 2026. Subsequently, on after that, from that, we filed his review on 26, 2026. So from that, there is 144 days.
Reviewable order does not extend limitation.
There is a benefit, section 14, benefit under limitation act. There is there's some difficulty to be,
Even that order was of the Supreme Court was passed on 27 January.
yes, 27 January, yes. After that,
You have not shown any urgency in coming here.
there are two reasons, my lords. I'll be very fair, my lords. One reason is, of course, the person is in detention, and there was some communication gap on his part. And the other was also difficulty from my end also, my lords. You recall, my lords, I had an accident, so it will also take some time from us, from my end, to find it. We have a good grounds on review, my lords. And my learned senior on
But Mr. D.K. Agarwal, under counsel for the applicant and so for the respondents. Next, issue notice on this application, filed under section 5 of the Limitation Act for condoning the delay of 40 days beyond the period of limitation and filing the connected review application. Next, issue notice returnable on, give a date after 3 weeks, returnable on so-and-so. Requisite copies of the interlocutory application as well as the connected review petition be served on the Learned CGC State and Department Council within 2 days. Next, list on so-and-so.
21 of us.
grateful.
Item 24.
Meet with this lordship. I'm sorry, my lord is not there, my lord. I'm sorry, my lord is not there, my lord. My lord, in this case, we have taken steps on my lord 24/7/2026, my lord, and received justice from the registry on 28/7/2026, my lord. So, my lord, may I pray this matter may take up, my lord, after 4 days. In the meantime, my lord, will serve justice, my lord.
So far as state is concerned, there is no urgency, I think, in the matter.
My lord, we have nothing.
Then why after 4 weeks? We list it after 4 years.
Yes, my lord. Because, my lord, I have to serve.
We
the-
allow you to take steps. You don't take steps. We allow you to do the service by dasti. You don't collect it and serve it. State should
I have
serve it.
already collected, my lord. My lord,
When did you collect it?
2 days before, my lord.
In today's state cannot serve notice on a person.
And because it has to serve to the district of Malay Tinsukia, my lord.
It will impose cost.
Then my lord may take it after 2 weeks, for in the meantime, I will do the necessary.
If you don't serve it by dasti within 7 days from today, we are imposing cost on the state. We pass orders and then you don't comply with it. You don't take steps. You don't do it. There is no urgency. This is not a time killing process. It's not appreciated. And in the process, you are keeping those persons who have acquired higher qualification without taking permission in suspended in a quandary. The writ petitions were filed to challenge your directions that those government employees who had acquired higher academic qualifications without state's consent, they would be subjected to departmental proceedings.
So the NOC.
That was set aside. You file an appeal. There is a delay. How much delay is there?
Well, actually, I am not in this case, madam. I am appearing on behalf of MD Khatami.
108 days. Miss N.
S. Sutia, madam.
S. Then the council study person for the Education Department appears on behalf of Mr. N.J. Khatami and counsel for the applicant and prays for some time to file affidavit of justice service. Next paragraph. We notice that the court had passed had issued notice by order dated 11/3/2026 and directed the state to take steps within 2 working days. As steps was not taken, further orders was passed on 15/6/2026 to take steps by speed post and by way of Dasti. The steps was belatedly taken and the notice by speed post was issued only on 24/7/2026. And the counsel for the applicant received the Dasti's notice for Dasti mode on 29/7/2026. Full stop. Therefore, comma. There is the state is causing enormous delay in serving notice on the private on the respondents. Next paragraph. We grant
I have instruction to appear,
for all.
not all, my lord, at present, my lord, restaurant number 1 has contacted, my lord. So 1 week time may be given, my lord. I will take it.
Okay.
Your telephone.
Notice by Dasti is not served within 10 days from the date of the order. Oh, no, you have to take fresh steps. That Dasti service will not do. The returnable date was 31/7. So any service made beyond 31/7 would be illegal, not acceptable. Because the service must be returned within the days, within the time allowed. Service made after the due date is no service at all. I have authored many judgments, many orders on that. We are not accepting it now. You have to take fresh steps. That is gone. That last line don't say. Next one. We note the court notices from the order dated 15/6/2026 that the matter was ordered to be listed on 31/7/2026. Full stop. Therefore, comma. The steps issued on 24/7/2026 by speed post with AD and the notice by way of Dasti service, comma, if not returned within 31/7/2026 would be of no consequence. As the service of notice beyond the returnable date is no notice at all. As the notice is affixed by is likely to is not likely to be served in 31/7/2026, comma, the process issued for respondent numbers 2 to 14 is required to be taken again. Next paragraph. Mr. D. Goel, Learned Counsel, enters appearance for respondent number 1 and pays for some time to file wakalatnama. First of prayer is allowed. Next paragraph. The applicant shall take fresh steps for service of notice on respondent numbers 2 to 14 by speed post with AD as well as by dusty mode. Next, 3 days time is granted to the applicants to take steps positively without fail. Full stop. The process for dusty should be routed through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph. The learned counsel for the applicants shall collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next paragraph. The fresh notice issued on the respondents number 2 to 14 is made returnable on, give a date after 4 weeks, returnable on so and so, list on so and so. 3 days time now from the date of the order, working days, 3 working days. We'll continue post lunch.
For admission, daily list item 8.
None appears on call for the petitioner. All the respondents are represented. For ends of justice, the matter stands adjourned today. List again on, due date after 2 weeks.
For admission, item 9.
They want to hear.
For admission, item 10.
No, please, your lordship. Okay, so the
I don't have time. I need report.
Here, the case of the petitioner
lordship.
is that uh, that she and her grandfather's name are there together in the voters list.
Her name was just recorded with the grandfather.
Hmm?
Her name was not recorded with the grandfather or father, but her grandfather's name existed prior to 1971. In the thereafter, the name of her father was recorded, and subsequently her name was
But
recorded.
we'll take it up next week then.
One more job. Yeah.
Yes, no, right.
On the on the prayer made by learned standing counsel for the modern active matters for the matters adjourned today. List again on, give a date after
17 or 19 maybe convenient, lordship. 17 or 19 of August, lordship.
17th or 19th of August.
19th.
Duly applies, lordship.
For admission, item 12.
How did you explain your changing name of your father? Kokamia, then Bakamia, then he becomes Habib Ali.
Initially, his nickname was Kokamia, your lordship. So that is what initially got recorded, but subsequently his name was Habib Ali Laskar, your lordship. At page number 4, your lordship, I have given a chart, your lordship.
Which page?
Page 4, your lordship.
4.
Before that, on the last question, lordship has perused that the Election Commission of India has given that the lordship was cited as opinion instruction lordship with respect to annexes 15 and 16 and 17 lordship.
And
This
it's
case-
15, 16, 17.
In this case, a district election officer, they took an initiative to remove the D lordship. So as a for seeking clarification, we are right to obtain instruction lordship. I obtained the instruction. As for the CO. So it's on 17 till 26 lordship. Till now, the name has been marked as D lordship. Since, and the CEO has observed that after a petition is marked D by the election commission, thereafter,
In
until a order is passed by a judicial
opinion,
authority,
okay.
district election officer has no authority to remove the D lordship.
Okay.
So as it should not be taken into account because it is because of that the D was never removed. And now that the foreigner tribunal declared him a foreigner, the steps will have been initiated to remove, delete the name lordship.
Okay.
In 2017 portal list, your lordship, serial number 461 is marked as D lordship. In earlier petitions, in earlier portal list, there was no mark D, but for the first time in 97, D was put here lordship. D started in 97 itself.
It was in 97.
First time.
That we have elaborately dealt with on many occasions.
It was on 26 also, it will mark as D in serial number 636 lordship.
Ms. Laskar and counsel for the petitioner. So all the respondents are represented. Next, for pursuant to order dated 17/6/2026, the Mr. A.I. Adil and standing counsel for the border and Election Commission of India has submitted that he has received written instructions dated 16/7/2026 from the Joint Chief Electoral Officer, Assam, Office of the Chief Electoral Officer, Assam, to stop referring to the same, it is submitted that mere marking of an individual as inverted commas D within bracket doubtful voter by the electoral registration officer is not a conclusive determination of the individual's citizenship status. So in this case, as the ERO had a doubt on the citizenship of the on the citizenship of the petitioner, his upon inquiry, his name was marked as inverted commas D voter. First of all, it is submitted that once a person is registered as a D voter, he continues to remain so unless he is exonerated by the foreigners tribunals. First of all, it is submitted that in this case, as the petitioner has been declared to be a foreigner by the impugn opinion dated 24/2/2021, comma, the D mark against his name in the voters list cannot be removed. Full stop. Full stop. The said instructions are perused and returned. Next, accordingly, the matter will be heard on merit. Next para. List the matter again in the admission column on. Give a date after a week. Either 1 week or 2 weeks, whatever is convenient. We are returning you this record. Oh, sorry, Shadi. We are returning you this.
File an affidavit in that regard for the reason.
Not required. You see, that is something we know. Once there's a D voter, by operation of law, he is referred to the foreigners tribunals. We have authored not one, but several judgments have been in the several orders. We have expressed that. So there is no requirement of any affidavit. That is a law we have laid down. Because this ERO reference is not a reference under Foreigners Act. It's a reference under the Representative of the People Act 1950. And there is a very recent judgment which Supreme Court has said that the Election Commission of India cannot determine citizenship. It can only refer it to the foreigners tribunals for decision. So that has been done. It's a well settled law. And once you are declared to be a foreigner, you don't think your name of D will be removed now. Correct. From D you have attained more qualification of now DFN, declared foreign national. Next.
For admission, item 14.
Item 14, we are newly engaged counsel in this matter, Your Lordship, and the brief is yet to be received from the petitioner. He is suffering from some vital medical issues. We haven't received the brief. We have followed.
Your submissions are contrary to the law laid down by the court.
Understand, Your Lordship, but we are also helpless. We have not received the brief also. Just we have filed the wakalat.
Okay, both sides are represented on the prayer made by the counsel for the petitioner. The matter is reluctantly adjourned. So we make clear that on the next date of this thing, matter will not be adjourned. List on. Give a date after 2 weeks.
Problem.
19th of August.
Item 15.
Before I enter into my lord, may I take your lordships to page number 67 to 73 inquiry report, ma'am. Kindly see. Page 67.
my lord. Form 1, my lord, page 67. Only petitioner's name and his father's name mentioned here, my lord, and then untrace. All pages are blank, my lord. Then form 2, my lord, page 70. Untraced, my lord. In fact, my lord, there was no inquiry. For the temporarily, my lord, the petitioner in the year 1998, my lord, after devastating flood, my lord, for livelihood purpose, he came to Guwahati, my lord. And in his absence, my lord, the house owner, he stayed in the rented house, and the house owner, my lord, furnished some information, my lord, to the police. And on that basis, my lord, this case was registered. Form was filled up, only name, my lord. There was no fair inquiry, my lord. He belongs to, my lord, Lokhipur Police Station of Golpara district, my lord. Then, my lord, inquiry could have been done, my lord, by the local concerned police station, my lord. But that was not done here, my lord. And inquiry officer, my lord, forwarded this, my lord, to the learned tribunal for, my lord.
Don't take an offense, we are just asking a question. Is your presence in Guwahati recorded in any police station? Supposing you are residing within the jurisdiction of Chandmari police station,
My lord.
now you have come here to High Court. Have you informed the Latasil police station? No.
No.
Therefore, you see, a citizen doesn't have to inform. So how will the police know that you have shifted from this place to other place and then send the inquiry there?
No, my lord. My PS name is there, my lord, mentioned Lokhipur, district Golpara.
You see, you are suspected to be a foreigner here. The inquiry is here. Then you suddenly leave. The inquiry will not follow you.
That is correct, my lord, but there was no inquiry, untraced, my lord.
And that's okay, we take cognizance of that.
Nothing mentioned, my lord.
You said that the inquiry should have proceeded in the other police station. That leads to that query. People travel all around, it's not possible for the inquiry to be there unless you inform the police station, every police station of your movement.
And in the written statement, my lord, I took that plea, my lord, and prayed for fresh inquiry, my lord, but that was ignored, my lord. And then, my lord, declared foreigner, my lord, on the ground that, my lord, there is some discrepancy in the name, my lord. That is the question. Mother, my lord, adduced evidence as BW2, my lord. Then concerned Lot Mondal also, my lord, appeared before the tribunal as BW3, my lord. He, my lord, proved some land document, Lot Mondal, and mother, my lord, says that petitioner is her son, my lord. Father's name appeared in the 1966 voter list.
Just a moment. Which page is your 1993 voter list?
1993 voter list, my lord, page 46, my lord. Yes, sorry, my lord. 46, my lord. 46, this is my lord translated. 47, Bani Pilama. Ahmed Ali, my father, my lord.
And
Kolimuddin, grandfather.
your father is
Father is my lord Hamed Ali.
Ahmed Ali.
Hamed Ali.
And grandfather?
Grandfather Kolimuddin, my lord. And somewhere, my lord, Kolimuddin Sheikh also has appeared. And Mohor, my paternal uncle, my lord. Mohor Ali. And Ramzan Ali, myself, my lord. First time my name appeared in 1993 botanist, my lord.
Your mother's name appeared in which voters list?
My lord,
Your mother's name appeared for the first time in which voters list?
mother's name appears, my lord. Nineteen 71. Page 40, my lord.
1970.
My lord.
Which page is that?
Page, my lord, 40, house number and serial number and relevant, my lord, 41. Shubjan Nessa, Abdul Hamid.
Yes.
Then, my lord, mother's name appeared in the voter list 1970. Then 79, my lord.
Mr. Mullah, we'll take it some other day because the PSC matters coming up.
My lord.
We'll definitely take up that
My lord.
first. Mr. Sharma, please make a note, you'll have to go through the records.
Sure.
He has a connectivity to the grazing reserve village.
Yes.
All the voters list come to that village. There's only a discrepancy of names.
Names, yes, sir.
And this Tikimari grazing reserve, that's the consistent address.
Sure.
So apart from some discrepancies. So that you'll have to examine the record.
Sure.
Documents appear to be there. Both sides are represented. Due to positive time, the matter could not be taken up today. List on your date after 2 weeks.
Deeply obliged to.
Just make a note on the next date you please see the records. We propose to take up the APSC matters now. I think for other matters, we will not have time after this.
The whole series, several of them have come up today. Well, let's read it. Start from 23, Lordship. 55 is fixed for orders, madam. Item 35. 23 is one set, there's 23, then there is 25, you've done. Review? Review हो गया ना विषय का?
Series starts from 23.
Yes, Lordship.
We take up serially, then
Item 23.
My lord, in item 23 and 27, 28, Mr. Diganta Das is appearing. Oh. He's holding the brief, my lord, in 23, 20.
okay, so that will not be before us. Okay, item 23,
Item 23, 27 and 28.
23, 27 and 28. Here you have to say that the learned counsel for the petitioner is present.
Which date?
list the matter before any other bench without one of us. Honorable Mr. Justice, the phone count. 23,
23, 27, 28.
27, 28. Okay.
Give your best. I guess date will get notified, Lordship. Date will get notified in due course.
Yes, because it will be not before.
I understand. That's why I said it'll get notified when it comes. Lordship, in 25 is the review.
Yes.
Lordships have already kept the review on the 31st August.
Item 30 has been made.
And Lordship, today item 30 already that order Lordship has passed. We've given the order to the court master. So therefore this can also go on 31st Lordship.
20,
Because
25.
the reviews will be dealt with together, 2 more are to come also.
25.
Yes, Lordship.
Okay.
But this is K.N. Chaudhary, sir. Yeah.
KNC sir is here.
We are putting it for 31st.
Much as a representative.
26.
Mr. N. Kobi, in the counsel for the petitioner commits that similar matters are slated to be listed on 31/8/2026. So accordingly, this matter is deferred. That is listed on 31/8/2026. Yes.
Now, 26 is also a contempt matter, but again, Mr. Chaudhary is in it, Mr. K.N. Chaudhary. Lordship, we are there in both the matters. 25, 26, no?
25 is being
25
deferred.
we have put for 31st because other reviews are going on that day. Okay. But 26 has just come.
31st को.
August.
31st.
Okay, no issues. And then this other matter also on 31st?
31st.
26, what do you submit?
Is contempt. 26 is a contempt matter, Lordship.
26.
Nothing to do. Lordship, the probationer, who they have alleged as probationer, he has completed his probation period, Lordship. A perusal of his service tools would show that. Lordship, for an excise officer, the maximum probation period is of 2 years. We have completed 4 years of service, Your Lordship. Therefore, we are in no way a probationer, Your Lordship. Our AIO is, Lordship, already filed it. So it has to be argued. Any rejoinder, Madam? No. Rejoinder? पूछ लो बाद में मत करना हाँ
Okay, we have issued notice, you have filed your response.
Yes, yeah.
It is to be argued.
We'll do it today.
Today, Your Lordship, same date, Your Lordship will argue.
No, because that is review and these two we cannot be possibly clubbed together. Two issues will be in tangent.
The contempt may come up on some other date. Your Lordship, maybe just 2 minutes ago, that other matter was being recused from the bench. Maybe this can be tagged along with that because they are also contempt matters.
No, we don't know where, because this is, you see, for some disability, we can't take up that matter. So.
I'm leaving it. I'm only a suggestion. I'm not.
No, it's okay, but.
It was not with any other intent to say not to be argued. I just thought because 3 matters were going to go separately, that's why.
Okay, let us finish this and then we'll come to it later. Let Mr. Chaudhary come.
Lordship, then after some time. Number 35, no? मेरा वो file दे दो. पूरा मोटा वाला file दे दो.
After some time. This is
Item
for the
number
delivery of orders.
35.
It's for orders. Hearing was concluded last day.
Just wait for some time that we will hear Mr. Kane's only first and then
Very well,
we come back to it
very well.
after some time. বাকি FTC রয়ে গেছে টাকা দিব FTC রয়ে গেছে মানে দিব FTC রয়ে গেছে মানে দিব আচ্ছা প্লিজ খারাপ খারাপ না করে দাও in FT matters are is anybody available here? You're there. Which are your items?
17.
17.
My lord.
Yes. Come.
In
Yes.
Lord, impugned order, page number 40, my lord.
Yes.
My lord. First, I will take your lordship through page number 45, which is 1965 voter list, my lord, of the grandfather, my lord.
Where is your written statement?
My lord, written statement is page number 27, my lord. 27? Page number 27, my lord.
Yes.
Number 45 not grandfather voter list lot 1995
Page number?
45 not.
Yes.
The grandfather.
Yes.
89 minutes. 89 was from the father's name here. Same village, page number 57.
57.
89 where one husband, the father, Safia Begum is the mother, and Rabia is the petitioner.
So after 1970, you have
My lord,
1985.
70, 75, 77, where grandfathers and uncles' names were there, my lord, but the petitioner's father's name was not there. He was working in different places in Mizoram, Manipur and Meghalaya.
75. Which 75? Which page?
75, which page number 49.
Yes.
51. Grandfather name continues. He is Lucky Brown.
Yes.
Then, my lord, 1989 is the father Usman Ali. Page number 57, my lord.
57.
57.
Usman Ali is your father.
Father, my lord. Village, my lord, may
His
note.
name comes from the first time here
First time here.
at the age of 50.
50, my lord, yes.
Yes.
He died in the year 1991, which is mentioned in the WS, my lord. Then, my lord, 1993. Page number 59, where mother and the petitioner's name is recorded.
Nineteen 1993 voter list.
93, page number 59, my lord.
Yes.
Yes. This is mother Safia Begum and Rabia Begum is the petitioner, daughter of Usman. But 1991, father dies, so my lord, his name is not there here.
Yes.
So, my lord, this is my primary structure of linkage, my lord. And the brother appeared as DW2, which is, my lord, the deposition is page number 96, and before that is the evidence on affidavit, my lord. The deposition starts from 1996, sorry, page number 96, and 87 is the evidence, my lord.
The appearance of your mother makes it very difficult for us to accept anything. Okay. Yes.
My lord, the DW's name is recorded in 1997 with the mother. By then, the petitioner was married, so her name is not here, which is at page number 63.
We've seen that. 63, we've seen that.
1997, 2005, and there is an ID card which shows that they have a common father. So this is my basic case, my lord, that the grandfather's name was there in 65, 70, 77, 75. Father's name, mother's name, petitioner's name, 1989. Father dies 1991. Petitioner's name, mother's name, 1993. She gets married, so then her name is recorded with the in the matrimonial home. Brother's names in subsequent voter list. Brother deposed. So my respectful submission is that, my lord, that there is a chain of linkage, my lord, and there is no shifting. Everything is in the same village. This is my basic case, my lord.
How do you link yourself to your projected parents?
Beg your pardon?
How did you link yourself to your projected parents?
The 1989 and the 1993 voter list, my lord. Where 1989, the father's name and the petitioner's names are recorded together.
1993.
1993 is with the mother. 1989 is the father, mother, and the petitioner.
Where is that?
This is page number 57, my lord. Page 57, the vernacular, the type copy, type and translate copy. The next page is the vernacular.
This is 1989.
89, my lord.
And next photo list.
Next is 1993, my lord, which is page number 93. Page number 59, my lord. Because of the father's death, my lord, mother and petitioner name is there. 69. These are two foundational linkage documents.
How did the tribunal deal with it?
Beg your pardon?
How did the tribunal deal with this too? What is this?
I'm sorry, I did not get your lordship.
How did the foreigners tribunal deal with these two documents?
My lord, this is page number 42, my lord. They recorded it here. Page number 42, my lord. It's recorded here about these two. My lord, my lord.
Try to do the APSC matters first.
Grateful.
So both sides are represented. The positive time matter could not be taken up today. List on services. Give date after 2 weeks.
My lord, in the mean, I may be protected in the meantime, my lord. I'm not on bail. I'd be grateful, my lord. There is a clear linkage and there is no enough explanation to reject these documents.
Posed by the understanding also for the active and border matters. Left considering the projection made in the lead petition and materials available in the travelers records, plainly stated into the petition to make bail of ₹5,000 to the satisfaction of Superintendent of Police Border Kachar, Silchar. This one, sir.
I'm grateful, my lord. Time being item 26.
Lord, this is a contempt petition, my lord. Now, as far as your lordship judgment is concerned, if your lordship would kindly come to page 145. I'll have your lordship's kind attention to para 141I at page 145. Operative portion, my lord. Fine. Those appellants who have completed their initial provision period of 2 years and by taking into consideration the maximum extendable probation period under their respective rules, that is, when so all the rules are quoted, my lord, are liable to be reinstated within a period of 50 days from the date of judgment of this order. So, my lord, all that your lordship indicated above, those who have completed 4 years, then they are entitled to be reinstated. Now, my lord, I may just indicate to your lordship, my lord, the petitioner was appointed on probation on 18/8/15 and he was discharged on 1st of June 2020. So he has in fact completed more than 4 years. Now, instead, my lord, what the authority is, if your lordship would kindly have the affidavit.
Date of joining is?
Date of joining is 18/8/2015. And my lord, the discharge order was of 1st of June 2020. So it's almost 5 years. Now, my lord, the alleged contemner has filed an affidavit, my lord.
When will you get these 2 dates?
That is an admitted position, my lord. There is no dispute on that.
Okay.
My lord, it is not clearly indicated, but there is no dispute, my lord.
Okay, 18/8/2020,
15.
15/8/2020.
18th of August 2015
18th of August
is the date of appointment.
2015.
And 1st of June 2020 is the discharge order.
Okay. Yes, okay.
And if your lordship would kindly have the discharge order which the alleged contender has annexed to the affidavit at page 191. Page 191, my lord. Whereas in compliance of the directions at para 141.2, read with 141.7, this is what they have invoked, my lord, passed by the Honorable Gauhati High Court in writ appeal number so and so and other linked cases, read with the orders passed in IA dated so and so, Governor of Assam is pleased to withdraw the government order discharging Abhishek Barbara, Inspector of Excise, from the service-wide notification dated 1st of June 2020. And whereas as directed by the Honorable Gauhati High Court, the case of Sri Abhishek Barbara, who was on probation in Assam Excise Service at the time of discharge-wide notification dated 1st of June 2020, is considered, and upon consideration he is not found fit for confirmation and being a member of the Assam Excise Service. Now therefore the Governor of Assam, in exercise of power conferred under Rule 19(2), read with Rule 18 and 21(2) of the Assam Excise Rule, is pleased to discharge Sri Abhishek Barbara, Inspector of Excise Provisioner from service, with effect from 1st of June 2020, that is the date of discharge given by notification dated 1st of June 2020, which stands substituted as directed by the Honorable Gauhati High Court. My lord, there are two ways of looking at it, my lord. Of course, I can also assail this order in a new writ petition. But my lord, prima facie, my case is covered by paragraph 141 Roman 2. They have invoked, my lord, 141 Roman 7. Is paragraph 141(1)(2) so unintelligible for the state of Assam to comprehend that they have to invoke subclause 7? So on the face of it, in my humble submission, my lord, there is a deliberate contempt of this, or it's a clear case of deliberate contempt of this honorable court's authority, my lord. It's not that, my lord, it is very difficult to find out how many years I have spent. It's a different matter, my lord, in service jurisprudence, especially with regard to law relating to provisional and confirmation. Confirmation is not an automatic concept. There has to be an order of confirmation. But having regard to the nature of the order which your lordship has passed, was it so incomprehensible that they had to invoke clause Roman subclause 7 instead of 2? And my lord, that Roman 7 is at page 147, my lord. 147. This is the clause which they have invoked on top, my lord. If there are any appellants whose probation period has not been completed, they would not become entitled to be reinstated in service. However, in respect of those appellants, competent authorities in government shall pass appropriate order to withdraw their respective discharge order already passed and to substitute the said discharge orders with simpliciter discharge order of not having found them fit for confirmation, so that no stigma would be attached against them. So that's my humble submission, Miller, for the present now.
Present means this would be the last hearing.
Miller?
Present means this would be the last hearing because I am proposing to pass orders in one of the matters.
Yes, Miller.
So therefore there will be hardly any scope for further hearing.
Yes. And my lord, it's my duty to point out to your lordships, my lord, since it is a content jurisdiction. At the end of the day, it is our duty to point out to your lordships, my lord, and your lordships will take a call in the fitness of things. But privacy, my lord, it is not a, order which is so difficult to comprehend. And in paragraph 150, my lord, initially this order was not included, my lord. We had to file an IA. At page 151, if your lordship would kindly see, my lord.
Yes.
Now kindly come to para 5. Accordingly, this court is inclined to order as follows, that at the end of the chart in paragraph 5 of the State Common Judgment and Order, a column be inserted under the heading Assam Excise Service containing the following column: serial number 53, writ petition, petitioner, that is one, writ appeal so-and-so, Obisek Barbara, accused number 41, supplementary charge sheet number 4. At the existing paragraph number 54 of the said judgment, an order a new paragraph under heading Assam Excise Service 8/1990 be added, with Rule 19(2) quoted as hereinafter. Then, my lord, at the paragraph 6, accordingly, this order shall be read together. Sorry, my lord, on top. At the end of paragraph 62 of the said judgment and order, a new subparagraph 6 be added with the following sentence: as per provisions of Rule 21(1) and proviso thereto of the Assam Excise Rule, the provision period is 2 years, subject to extension not exceeding 2 years. So 2 plus 2 is 4. Accordingly, this order shall be read together with the judgment and order so and so passed in writ appeal number 12. So that is my humble submission, my lord.
This is a matter where the end of that series did not leave me with peace.
Correct.
Hmm?
I can appreciate it. And of course, my learned friend has pointed out one thing, my lord, that the earlier incumbent in the office of the Commissioner of Excise, I am told he has since been transferred to another department, and a new incumbent has joined. Anyway, my lord, that's a procedural part. We'll take note of that. When it comes to, we invoke our jurisdiction against Virender Mittal, who is the incumbent, that question will arise. For the present, my lord, I think this will suffice.
Yes.
I'll make it brief. I can't, and I'll just sum up what has been our arguments consistently. So, Lordship, respectfully, Ladyship, everyone who's approaching this court and raising an argument of contumacious act is starting in the middle of the story. For the state, it has been one continuum from day one. And that one continuum has been that the officers who were discharged under the statutory rules, their status was of a probationer. This is the continuous story of the state. And this is exactly, only Lordship, to point out, is going to be and is the argument continuing in the Supreme Court, where some of them have filed an SLP. The state hasn't filed an SLP, Lordship knows. We are on a limited point of para 67, 68, because the statutory rules were not under challenge. So there's an impact of the judgment on the statutory rules. Hence, we have filed that. We've implemented the judgment. So to close the loop, if I may say so, day one, the state stand is that certain individuals that feign of a tainted entry into the service arises. And such people, if they occupy public office, it goes against public interest and public trust in the office. This is the continuous story of the state, or the stand of the state, not story. Second, under all law,
A probationer is a temporary employee, akin, in government or otherwise, akin to a private sector. The settled law consistently has been probation. If a situation like this comes, the objective of probation is served. What is the idea of probation? To see that the person is fit for the office, suitable for the office. In government employment, coming out of public funds and for the interest of the public, suited to public interest. That is the probation. Our case is that, again, based on several judgments, which Lordship has considered also, that 2 + 2 is the period. And if it is extendable, then you can, there are two parts to it, Lordship. One is the probation period, and then there is the act of confirmation. These are the 2 points under the statutory rules, in which there is departmental exam, there is the question of the second increment. Lordships have dealt it. That is why also our review has come, because several people have not received the increment, second increment, though the judgment so said so. So it is our duty to come and assist the court and point that out. So this is on the first part, which is on who are the people, what is their status as for the government, and hence, Lordship, we now come to Lordship's judgment, because now what will be in session is going to be Lordship's judgment. The judgment, our stand is not an unequivocal relief to them. It is a conditioned and conditional relief. I'm using both words. Conditional
Yes.
Conditional and conditioned. Conditioned to the facts. Conditional to the relief. The relief being link it to the service rules. Now, a question arises, Lordship. What does the state look at? The findings or the directions? It's as simple as that. Will we be driven by the findings or the final direction, which is 140, Lordship? The state has gone with the final directions in para 140, because we, in implementing, cannot choose to interpret the final direction. The direction says
This is-
appoint.
Incidentally,
Lordship.
is not offensive to you, but incidentally, this is something which we are facing daily. With the e-mode of reading, which is now prevalent, we are burdened, we are bulldozed with several judgments with one-liner, two-liner. And when we read the entire judgment, it goes against the. So therefore, whether a sectional or dissection reading of a judgment is permissible, that will be a question.
So in fact, Lordship, if I may assist you, I'm not making it as this, and I'm very grateful that Floyd, this is going to increase in the age of AI. It is going to, because people are coming with you. I'm today from morning got 7 emails on a matter where the litigant is interpreting every line of the judgment and writing to the employer. And finally, I said, shut the door and tell him to go to court. This is exactly what I said. Now, coming back to what Lordship said, their Lordship Justice Sanjay Kishan call in one of the judgments. In fact, that is the state of Gujarat versus, it's related to electricity law, UTT. So it was on Utility Welfare Association of Gujarat. But their Lordship had used the inverse ratio point. What is a ratio? What's an arbiter? This is something that also many people miss. The ratio is in terms of what is the holding finally in the facts and what is to be done. The arbiter is a view. So the question to be seen is, if you inverse the ratio, what will happen to the judgment? If you inverse the arbiter, what will happen? The arbiter will not change the ratio. But if you inverse the ratio, the judgment will be changed. So therefore, Lordship, finally for us, and I must say so because I've been in this litigation for the beginning, from there to now, my hair has gone from black and white to white. So I've been in it throughout, but my, this was, and when, with our learned AG also when we sat, the view was, how can you go against the direction? I mean, there is a direction. That direction is conditioned and conditional. So we've gone by 7, 2 and 7. Either it should have said clearly, reinstate them. We hold they are not probation. But if you are a probationer under the statutory rules, then what? Which is what we've done. So that is on the judgment. I'm not, Lordship has authored it, so there's no point by reading it again and again. I have argued it earlier. So I'm making the principal points. That brings me to the next leg, Lordship, which have 3 legs. The first is what is contempt. I mean, the basics. It's a narrow, it's a rare, and it's an extraordinary, beyond the ordinary jurisdiction. This is the only jurisdiction where the prosecutor, the accused, and the judge are one. There's no other jurisdiction. That is why it's rare. It is for the majesty of the court and the majesty of administration of justice. There's no doubt. So in which, and it's settled law, there is no preponderance of probability. It has to be beyond reasonable doubt, just as in criminal trial. That beyond reasonable doubt rests on 2 words: willful and deliberate. It rests on 2 words, just open. Willful means an act with mens rea, if I borrow from criminal. That I sit down, I then apply my mind and intentionally, with mens rea, with intention, say, I will not do so. In the judgment of justice, we have quoted it also, which is Balwantrai Somabhai, Lordship, of Justice Pardiwala. It's in a also affidavit of opposition. There, for example, the facts were that an undertaking was made in a court. Very clearly, I will not sell the land, and they sold the land. You can't escape out of it. In our case, Lordship, I'm going to respectfully say the definition of contempt under the Contempt of Court Act is basically, has to be willful disobedience with mens rea of a direction, whatever. Now, Lordship will also read it with section 12, which is once there is a finding, and Lordship is a 2-step approach. The 2-step approach is, respectfully, Lordship, of course, I must also point out, this is a learning for me, because I have had no occasion to, we've argued contempt several times, but go through the process from beginning to end, how it happens in a court. So therefore, we are often, because of the government in courts, pointing out there is no contempt. But when we are at the point of an order, Lordship, it's a 2-step approach. The first step, Lordship, is the finding, which has to be beyond reasonable doubt. It has to be unequivocal finding of a willful and deliberate act, which means with mens rea to impede the administration of justice. It's mens rea in terms of the act of issuing an order. But for what? Impede the administration of justice. Then comes the next leg. Is an interpretation possible to the direction? Can there be a second view? Can there be an alternative view? Can there be the need of a clarification? That would, there is law on that also, Lordship. I've placed those judgments. If Lordship wants, I can replace them. They're all in the Suranjita matter. That's why, Lordship, I'm being brief. I mean, I'm conscious it becomes too much going on again and again. But I'm only talking of the principles, Lordship. Therefore, the judgments are there, the paras are there. The next step is, if there is an interpretation possible, an alternative view possible, there can't be contempt. There is a third leg also, which is why I said it's a very narrow and a very rare. jurisdiction, an extraordinary jurisdiction. Is it an execution? It is not. Now, contempt is often used for execution. In civil law also it is used often. Some people do get through also, in fairness, because then the authorities say, why go through the procedure? But why I came to...
Principle, it is for enforcement of orders.
It's right. Yeah, of course, Lordship. I don't know. I did not say Lordship. I'm not making it sway Lordship judgment or the proceeding. I'm making a submission in terms of how it is also used in other cases. I never said this case, sometimes. I'm very clear about what I'm saying, Lordship. It is for enforcement, and in enforcement, the two things will then come, Lordship. Is there an alternative view? And there is law on that also. Would a fresh cause of action be the appropriate act? That is also the law. P.C. Gupta's case, one of at least them was Justice Gauhati wrote that judgment, if I recall. So if there is a fresh order, would that be in terms of enforcement, or would that be a fresh cause of action? If now in this particular case, the directions stand, I'm sorry, Lordship, but I think behind the doors, I don't know whether I'm exceeding my time and holding back. Does Lordship have to rise?
Yes, we have to, you can continue 5-10 minutes.
Yes, I'm grateful because the door was open, so I kept silent. I'm almost closing it. I'm reaching there, Lordship. So therefore, Lordship, the next was, will it be a fresh cause of action? After all of this, willful and deliberate, is an interpretation possible or not? Can an alternative view be there? Is there a fresh cause of action? And just to close the interpretation, that interpretation is possible also arises that there are two separate reviews. The state's review is not going to be on that aspect, but a review in which a notice is done is going back to the findings. That there is an alternative view is also evident from the fact that one series of people have gone to the Supreme Court challenging what otherwise another series of people are taking to be an order in their favor. That means within the petitioners also there are two views. Within the petitioner councils also there are two views. That it requires challenge and interpretation. It requires acceptance, no challenge. One series is no, a review is needed. So all the three options are before the court. As in the court means the court, not the bench person. After all this, Lordship, we come to section 12, which is the punishment. And if Lordship sees that also, and 12 is interesting, Lordship. The punishment. I'll read it otherwise. One sentence, Lordship. I can share from Mr. Chaudhary and give my comment.
No, it's okay, we have it. Just it displaced from here to there.
There is enough on the table in any case. Enough on the table in all senses.
Yes.
So, Lordship, I find it instructive when I see the intention. Is, Lordship, that save as otherwise expressly provided in this act or in any other law, a contempt of court may be punished with simple imprisonment for a term which may extend to 6 months, or with a fine which may extend to 2,000 rupees, or with both. But the proviso is important. Provided that the accused may be discharged or the punishment awarded may be remitted on what? On apology being made to the satisfaction of the court. So even now, look at the framers, the legislative intent. Even after the threshold of willful and deliberate, the high threshold is crossed, the framers yet have left, because the idea is not punishment. The idea is administration of justice. This is not a crime against society as in civil criminal law. This is administration of justice. If it is administration of justice, then the three legs that I just argued about will also need to be considered, which is as per judgments. So where I come, Lordship, to close the loop completely, is we have, in a bona fide waiver state, implemented the judgment, and we bona fide believe that we have followed it in letter and spirit. We have consistently in all the petitions read, if there is an unintended, certainly not deliberate, certainly not willful, any impression also, our apology is absolutely unconditionally before the court. Because ultimately, the state is also for the people and public interest, as is the administration of justice. There is no difference on our that. So where we are, Lordship, that's where we are. Now, I am duty bound as an officer to assist the court, even if the facts can be argued against. And that's what as seniors, all of us are supposed to when we have it on. There is a slight difference in this case as compared to the other. And I would be failing if I did not bring it to your notice. In all other cases, the discharge is prior to 4 years. This is the difference. In this case, the discharge is after 4 years. But then the question comes, what is our defense? This is the difference in it. I think this perhaps is the only case. It is the only case. In this, our defense, Lordship, I would request Lordship and Ladyship to come to para 11 and 12 of our affidavit in all. Page 164, Lordship. All Lordship, Ladyship may note on page 164, bottom of the page. Lordship, I've quoted all the law before this. Lordship has dealt with it, so I'm not getting into it. But 11, Lordship, is a table. What I'm requesting Lordship, Ladyship to see is on page 165, para 12. And once Lordship has it, Ladyship has it, I'll just like to read it.
Yes, please.
Yes, Lordship. As evident from the table above, Mr. Chaudhary will believe that lawyers do give intelligent answers. Since you are smiling on what we have put there. As is evident from the table above, the petitioner was arrested on so-and-so date after completing 2 years initial probation, but before completing the 2 years maximum extendable. Therefore, why the point we are saying? Therefore, consequent to the arrest, the petitioner admittedly did not continue complete his probation. But this is another question of law. What happens if you are incarcerated during probation and on something which eventually the police investigation, etc., points to
I have
a
a very
credible?
interesting query.
Lordship?
I have an interesting query, not dependent on this state. It's in a different state where the protocol of service is 35 years of service or attaining of the age of so and so. That is there in one of the states within our jurisdiction, state of Nagaland. The law is that you will retire with attaining of the age of so and so or 35 years of service. Now, one man after 20 years of service gets involved in any criminal proceeding, arrested 2 years, not there. After that, can he come and say that 35 years of service means 2 years minus when I did not serve, and therefore I get 2 more years of service?
Lordship, I'm in fairness, this is the 7 emails that I'm dealing with. He's dealing with a question like this. For 7 years, I'm suspended, so extended by 7 years. It's the exact question. It's a coincidence that Lordship said so. Now, one more thing, Lordship, on the same point, which Lordship raised, which is about, probation, of course, my argument, I will press for Lordship's consideration, that the purpose of the probation stood serve. And therefore, the technicality of what is to follow, let me put it in a different way. You are in jail. You are now out of my jurisdiction, in the jurisdiction of the state, in a different way. So these are the questions. That little element is there in this, But because it is so, it is my duty to bring it to your notice. Can't gloss it and say, link it with the others. Of course, in Rule 18, Lordship, which is part of our review, not for here, but just to closure and complete the argument, is that, Lordship, the excise officers have to pass the departmental examination conducted by the APSC and undergo a 1-month excise warehouse training for confirmation of service as per Rule 18. That is the point. So there is an additional. So therefore, then there is the second part, which is the satisfaction, which he didn't do it, Lordship. But of course, that is not what I pleaded here. I'm only giving a wider context to the person. So therefore, Lordship, to conclude, and also, Lordship, on an aside, Wasim Beg, which we quoted the 3-judge judgment. Lordship, that one is an interesting case on fact, because the person was in this UP corporation and leather corporation, and he disappeared for 7 years. So he used to come to office when he chose and, rejoin or move away when he chose. And his termination also was, though with elongated time, upheld up to the Supreme Court. So I think the closing sentence, if Lordship and Ladyship would permit, is ultimately the administration of justice or the States Act to serve the public interest are identically placed through different means and mechanisms. It is ultimately all in public interest. And I would say, Lordship, having argued this, that the judicial magnanimity of this court may note all of this if there is an unintended, even indication, and I'm saying there is no willful, no deliberate indication that we have in any way sent an incorrect message also that this was to impede the administration of justice. Our bona fide, unequivocal apology is on record, and I'm grateful for that.
I just take 2 minutes, though I may not be entitled as a matter of right. Because my only submission is, in a civil contempt, your Lordship is concerned with only one aspect, whether the violation is willful and deliberate. Now, my Lord, what would be an willful and deliberate violation? There cannot be any straitjacket formula to determine, to be applicable in all cases. It will all depend upon the facts of each case. Now, by the judgment, your Lordships at para 138 had set aside the learned single judge's order. Now, my learned friend started his argument by saying this recruitment process had an impact in the public interest. Now, my Lord, these stories were not accepted by your Lordship. That is why your Lordship just set aside the learned single judge's judgment, lock, stock, and barrel. Therefore, end of the day, my Lord, my humble submission is, if what my learned friend has argued inspires your Lordships, that here is a case, it cannot be construed as an deliberate and willful, that is otherwise. My Lord, I cannot, my Lord, my learned friend's argument cannot be a substitute for what was going through the mind of the executive while passing that order of my Lord discharge. These are all matters of argument. That's why it's very important. Now, Lordship would recollect in MP Sugar Mill's case, it was a case of promissory estoppel. The question arose was, when state can be said that they can resile from their promise? Their Supreme Court says that it is the court's satisfaction. It is not the executive satisfaction. Now, the satisfaction of the executive that here is a case, it is covered by subclause 7 and not subclause 2, that is something over which Lordship will have to record a satisfaction. Prima facie, my Lord, is it possible, my Lord? Is it so unintelligible? Is it so incomprehensible between para 7, 14, 141, Roman 2 and Roman 7? Therefore, my Lord, my learned friend's argument has given credence to our belief that it's an act which was done deliberately. So it's a clear case where section 2B is attractive. It's a case of civil contempt. That's my humble submission. And from the chart which has been given, Mila, that I was appointed in 2015, that has come out very clearly.
But Mr. Kohli, we have a question for you. You see, we have in the other case of Mr. Chaudhary.
Yes.
No,
As in
Other
Chaudhary.
other Mr. Chaudhary.
35, Suranjita.
Here, in our orders passed from time to time, in fact, there are 3 orders where we have consistently said that the pendency of the contempt would not be a bar for purge of the contempt. Now, in your interlocutory application, you say that it's there is no contempt and therefore question of purge will never come. That means the authorities are the respondent contemners. They are not ready to accept that they are required to comply with the directions. Can there be a second view of that?
May I just assist Lordship on that? I think Lordship, there are 2 parts to, again, this particular case of Suranjita Hazarika. The argument is in terms of the service of the actual discharge notice. That is that argument has been professed also. But therefore, Lordship, let me now come, there are 2 parts to it. There is the order of discharge, and then there is the service of that order onto the person who is discharged. This is the 2 different things. The order of discharge, preceding it is the decision to comply with the direction and hence discharge. So first there is the decision to discharge. Where does the decision emanate from? The decision emanates from the directions in the judgment. And respectfully, the person who's professing contempt is identically placed to everybody else that the state has chosen to implement the directions against. That means there is she's not differently placed. There is no intelligible differentiator to say I am in a different class. This is my argument to the court, and it is settled law that contempt is between the court and the alleged contemptor. The assistance can be called upon, which it is called upon, and that is the beauty of this process. But this is not adversarial for him to supplement or interrupt that. I must make that. So therefore, coming back to it, Lordship, the judgment has directions, and we've argued consistently everywhere that the directions are unequivocal, they are conditioned to a circumstance, they are conditional. In conditional directions, there is 141 Roman 2, 141 Roman 7. This is identical to everybody. I have, as an officer of the court, duly placed it. There is one person in the contempt jurisdiction now where there will be a need to interpret whether being incarcerated would amount to a break of the probation and hence re-beginning, or amount to completion of the probation at the point of incarceration. It's a different class. So there is only one case that is in a separate class. Everyone is in the same bucket. And the state has acted completely uniformly against everyone in terms of compliance of the judgment. So I don't have, as the state, in public interest, any leeway, and also in the administration of justice, any leeway to act differently against 2 identically placed people when I, as the state, look at the service rules and the directions. Now, if I go, I have another problem as the state. If the so-called, let me put it like this, Lordship, if I reverse my decision, I am in a double whammy. I am now acting against the very directions of lordships which I have implemented. So how do I, so as we say lordship in Hindi, we have ek taraf kuwa, dusri taraf khai. In English, it is between the devil and the deep blue sea. So therefore, lordship, walk through very carefully between the two.
Supplement it, we say the devil wears a Prada.
It's a good film, by the way, lordship. It's a good film, lordship. It has a very good sense of humor, and I was delighted to see it because this old British humor is dying. It has now become so loud, everything we just, have to say it in the face. To catch a fine point in this, it's almost like law, lordship. Therefore, lordship. So now, lordship, I have a double problem. I have issued as the state a fresh discharge order based on the directions in compliance of it. If I reverse that, what do? I'm going now against the judgment. And I'm in a reverse position. And what happens to then? Equivalence. Can I choose to be, as a state, discretionary for the same class of people who identify? That's our challenge, lordship. And it's a genuine challenge. And that is why the argument in her case comes that if there is a fresh discharge order, and if I have implemented it as the state equally for everyone, then it's a fresh cause of action because others have chosen the fresh cause of action also. So I have now 30 writ petitions. I means lordship the state. I am for the state. I am now defending for the state 30 writ petitions approximately of those who have challenged that fresh ground of fresh discharge versus another class of an identically placed person who is choosing to take the contempt jurisdiction. I have to appear, and there's a third class of 8 people, and lordship, on that I have something to say which is very interesting. In the Supreme Court, I don't know how the court will take that, but there were 8 people who went to the Supreme Court. In that also, lordship, on the last date, Thursday, it was argued comprehensively before arguments. In fairness to my learned colleague there on the other side, he said, I am withdrawing for one person, because that person is already before the High Court on the fresh discharge. And that was going to be a ground of my defense immediately. No problem. Lordships took it. It was then argued fully for the next 2 hours. And now only balance arguments are left. Lordships also were very fair, as it often happens from benches, that, this is what our preliminary thought is. Convince us this way or otherwise. I want to get more into it. And it is on the point of closing. Now we've been served with an affidavit in which 6 people, essentially, the AOR quite rightfully has said that I am discharging myself because now 6 others have been moving parallelly with challenging the fresh discharge and are in the SLP. And the Supreme Court being in session of the matter. No, 1 minute. Why don't you come and argue for me, Mr. Chaudhary? My learned friend, now I'll say it, my learned friend has crafted, and I'll give him full credit for it, a strategy where somehow through any interlocutory order can we get to the larger picture, which we faced in one of the things. But now the state is also very agile. The state is also deciding to take it fully. But coming back to this, lordship, that is another aspect which I would respectfully say. If after arguments there is a withdrawal, and that too there is a non-disclosure, how the court will take it, what the court will do, while it is now hearing it and may come up in the next week or 2 weeks or 3 weeks, I don't know, lordship. So anyway, I'm just coming back to lordship's query. I am duty bound to act equally on all. I have implemented, done the fresh discharge. So lordship, I ask myself most humbly, how do I purge myself in contempt by getting into a situation that is contumacious in another sense? If I comply and it is contempt, then what happens to my compliance against all the others who are equal? Therefore, I'm in lordship and ladyship.
May I say something? Your lordship, asked my learned friend a query, saying that there are subsequent orders also, like the 18th February order, where your lordship gave a positive directive that the petitioner should be permitted to join our service. That was reiterated in the subsequent order which the lordship put to my learned friend. So what your lordship asked my learned friend was that the lordship's benevolence, that can you have a relook, a second thought? My learned friend's answer, my lord, over this is, the answer is only one word, no. So that, my lord, in fact, in my respectful submission, my lord, is a direct reference to the majesty of this court. If there is an order, my lord, my friend, the state will have to comply with, my lord. Irrespective of the fact, my lord, whether in doing that, my friend is saying he'll be discriminating against others. Answer obviously is no, my lord, he's not discriminating. There's an order of the court that needs to be complied with, my lord, interim or final. And my lord, my respectful submission is, my lord, the state is in contempt, and that contempt, my lord, is aggravated by the non-compliance of the 18th February 2026 order, which your lordship directed, my lord, within 30 days that my client should be permitted to join. So, my lord, the contempt proceedings should be drawn, my lord, and taken to its logical end. That's my respectful. Item
Abhishek Borbora, which is the other matter expert.
35, item
35.
35, supplementary item.
His is, Mr. Arnab Chaudhary's is 35, Suranjita, which was for order. May I? I was trying to look at this, Lordship. This is the first time even I'm there. So therefore, Lordship, on the face of it, first Lordship would need to pass an order on the first leg. How Lordship has held it to be deliberate and willful. After that order is there, then Lordship comes in terms of the framing of charge, which is a show cause notice that this is our finding. And now we show cause, and which will give us time to then again come back before Lordship. Of course, Lordship, in fairness, again, I'm assisting the court. In this period, the one on whom there is a contempt claim has the legal recourse to consider or to comply. So therefore, this is how it goes, Lordship, according to me, but we are in your.
Well, Rule 11 of the Gauhati High Court Contempt of Court rules, my lord. So it states, my lord, if I may read it. In the case of a civil contempt, the High Court may determine the matter of charge either on affidavit filed, affidavits are already filed, or on such further evidence as may be taken by it, or recorded by a subordinate court in pursuance of a direction made by it. Yeah. And pass such order as the justice of the court may. Frame the charge. Now it's the framing of charge.
Later, Lordship. I don't agree with that, Lordship. First, there has to be an order holding willful and deliberate.
Yes.
Otherwise, how will there be a show cause
When
notice?
your lordships are holding, my lord, by an order today that they are guilty of contempt prima facie. So your lordships will now have to fix the matter on a date when the gentleman will have to be present in court for framing of charge.
And with Lordship time for us to respond. That's okay, Lordship. Will you come up by tomorrow? Lordship, sometime.
No, it can't be, my lord. It has.
After? 3 is good. I was going to say 4 weeks. Actually, we are not very far apart. Only why, Lordship, and I'll be honest. There is, one second. There is the Supreme Court. I'm expecting that hearing will close. All of that will have a color on the larger thing. Which way? If the Supreme Court accepts it or the, maybe, which is, no, so Lordship, I'm not saying in terms of content. I'm just simply saying, Lordship, that because that matter is there 3 weeks, if it can be 4, it just gives us an additional week, that's all. It's just as a council and they're all busy, Lordship, it's quite bad. So 4 weeks is fair, Lordship, I think that's enough. Now, we are of course, Lordship, coming before Lordship on the 31st, which is a Monday. I am again coming, Lordship, before this court on the 7th. I'm just giving the dates. If it is on those days, it just becomes a little easier, but I'm in your.
26th August.
I'm 7th. So Lordship, I am coming on 2 dates before to the court, 31st and 7th of September. These are the 2 dates. 31st August, Lordship. We are already on 31st in any case. Correct. Lordship, order will come by tomorrow. Oh, it is tomorrow also. It's for Saturday in any case, Lordship. It doesn't matter.
Even our matters will also come up on same date, 26. Okay, ask.
Both will come up. Mr. D. Nath and Mr. A. Roy. Gopal? Yeah, so look, that's why I asked first, this, when I didn't get a reaction, I said maybe Gopal on BC. Grateful Lordship.
A few days, he's suffering from some cardiac problem. So, can it be posted in the next week? Yes. Well,